All right, yeah, are underway. So hello, everybody, and thank you for joining us today for this briefing on the Reforming Intelligence and Securing America Act, or RISA. This is an incredibly important bill that your bosses will be voting on, we think probably at least the first time within the next 24 hours, and definitely before the week is out. So we really appreciate you all taking the time to join us today and to hear about some of the civil liberties concerns with this bill. Before we get into kind of the substance of the briefing, I wanted to make a couple of brief programming notes. The first is to do with how we're going to structure this briefing. So we're going to start out with a moderated Q&A with our expert panelists, who I'll introduce in a moment. And we're going to go through some kind of preset questions so they can give us a sense of the issues that we're talking about. We expect that to take probably between 35 and 40 minutes. And we'll leave hopefully about 20 minutes on the back end of the hour to answer any questions that you have. So if you have questions, please feel free to put those into the Q&A box. The way it's set up is only myself and the panelists will be able to see who has asked a question. So there's no question too basic. We want to make sure that you have the information you need to provide your bosses with good counsel. And so please, if there's something you're wondering about, ask, because there's probably someone else who's wondering as well. The second note is that we are recording the briefing. I've heard from a number of people who are interested in hearing it, but weren't able to attend during this hour. So we are recording it. I'm going to turn off the recording when we get to the Q&A section. Again, that's just so that people can ask candid questions. They're not feeling any pressure because the questions they're asking is going to be answered on the recording. So if you're listening to this after the fact and have questions that we don't answer during the briefing, please just shoot me an email. If I can't answer your question, I can direct it to someone who can. So with that, I'd like to introduce our panelists. I'm really grateful to all of them for joining us today. They bring a huge wealth of expertise in these issues, as you will hear shortly. So we start off with Sharon Bradford Franklin. Sharon is the chair of the Privacy and Civil Liberties Oversight Board. Right, there's an independent executive branch agency charged with ensuring that our nation's counterterrorism programs respect American civil liberties. Next up is my boss, Liza Goitein. Liza is the Senior Director of the Liberty and National Security Program at the Brennan Center, where she focuses on a variety of issues related to executive power and surveillance. And then last up is Jason Pye, who is a Senior Policy Advisor at FreedomWorks. He holds some other roles as well, but I believe he's here in his FreedomWorks capacity and brings a wealth of policy experience. So thank you to all of our panelists for joining us. I'm really excited to kind of learn from you all today, as are our attendees, I'm sure. And so Sharon, I want to start sort of the substantive portion by turning to you. I imagine that the folks on the call are now kind of fairly familiar with a lot of the general outlines of Section 702. If for no other reason than they've read the PQOB's comprehensive report on it, right, that you all issued last fall. And failing that, because Liza, Jason, and I have been inundating their inboxes with emails. So this is a foreign intelligence authority that was intended to make it easier for the government to surveil foreign terrorists, but it's been repeatedly abused to spy on Americans. Can you tell us a little bit about some of the problems with how Section 702 has been implemented?
Sure. Thank you. And thank you for having me today for the briefing. I just want to start out by noting that I'm speaking today in my individual official capacity as my role. I'm not going to assume that people have read our 300-page report. I want to focus on just a few key points about how Section 702 does operate before getting to your excellent question. First of all, as folks probably do know, Section 702 allows the government to target non-Americans located outside the United States to collect the content and metadata of their communications. And they do that by compelling American companies, American communication service providers, to participate and assist in that collection. Importantly, targets do not need to be wrongdoers or even suspected wrongdoers. Targets need to be people who are reasonably likely to possess or communicate foreign intelligence information. So they themselves may be unwitting that they even know anything relevant to foreign intelligence. So I think that's an important point. And the program has been growing over the years since it was initially authorized by Congress. The most recent publicly available statistics are that there were over 246,000 targets, which was a 276% increase from 2013 to 2022. Another key feature I just want to note at the outset, it is what we call programmatic surveillance. The FISA court, the secret FISA court, reviews the topics of the collection, what they call the certifications, and procedures under which the program has to operate, but no judge ever reviews individual targeting decisions. And the reason for that is a good one. The reason is that the targets are people who do not have recognized Fourth Amendment rights because they're people, as I mentioned, foreigners outside the United States. However, Americans, when they are in communication with these targets, can have their information collected through what is called incidental collection. So turning to your question, yes, there has been abuse of this authority, but I want to mention a few examples as you asked, but I also just want to frame at the top, this isn't only about reforms to address compliance problems, to address the abuses. This is also the opportunity for Congress to impose structural reforms, to raise the bar in addition to ensuring that we don't have these persistent compliance problems. So just turning to compliance, things that actually violate the rules as they already exist, we've had the key problem has been with what are called U.S. person queries, and we're going to talk a lot more about that. But that is the feature of the program. Again, we'll talk more about that in a little bit, I know, where once the government has the collected data in databases, it can search through those collected communications, seeking information about specific Americans, specific U.S. persons. And we have seen abuses of existing rules where FBI is querying individuals associated with Black Lives Matter protests, with January 6th. In one incident, there was 141 identifiers associated with people in the Black Lives Matter protests. We've seen also NSA analysts running queries to check on a potential tenant for a rental property that the analyst owned, and another NSA analyst conducting queries seeking information on someone that they met through an online dating service. So we've definitely seen these abuses. But those are things that do at least violate existing rules. They have been detected. The big issues, though, also, this is Congress' opportunity to impose reforms to raise the guardrails, to improve protections, and particularly to address these threats that are posed by the fact that there is substantial incidental collection of Americans' communications, and that with U.S. person queries, in addition to, there is no judicial review, no external judicial review for those U.S. person queries. So I'll stop there for now because I know we'll get to those in more detail.
Excellent, thank you. That's a very helpful overview, and I really like the framing of raising the bar, right? Because I think it can be kind of easy to get sucked into focusing on sort of the abuses that we know about, and not talking about kind of how to restructure the program to ensure that those things aren't happening again in the future. And that's a really kind of great pivot to the question that I wanted to ask of Liza. Which is whether RISA, which is the bill that the Senate's going to vote on this week, includes the reforms that are kind of necessary to accomplish, kind of raising the guardrails, like Sharon talked about.
Thanks, Noah, and thanks everybody who is called into this Zoom to watch this. Unfortunately, RISA is a reform bill in name only, and in fact, it was drafted by leaders of the intelligence committees who are actually opposed to reform, but understand politically they have to have something that looks like reform. So it is intended to give the appearance of reform while, as much as possible, preserving the status quo. And it, at least when it comes to backdoor searches, that's what it's doing and or trying to do, and I think it succeeds. The bill's leading reform is a prohibition on U.S. person queries that are conducted solely to find evidence of a crime. In other words, there is no foreign intelligence purpose whatsoever. Now, that might sound significant until you realize that the FBI almost never conducts these searches. So in 2022, a year in which there were over 200,000 U.S. person queries, this prohibition would have prevented the FBI from accessing Section 702 data in exactly 2 cases. And it would not have prevented any of the egregious abuses that we've been talking about, the Black Lives Matter queries for members of Congress, queries for 19,000 donors to a congressional campaign, a local political party. All of those queries were purportedly intended to find foreign intelligence. The bill's other reforms when it comes to backdoor searches mostly just codify the changes that the FBI has already made to its internal procedures, things like enhanced training, supervisory approval requirements, changes to the to access to data systems. But those changes have proven to be insufficient. After they were implemented, the government has continued to report violations of the querying rules at a rate of about 4,000 violations per year. And the abuses are still continuing. We've heard about the government has reported backdoor searches for the communications of a U.S. senator, a state senator, and a state court judge who contacted the FBI to report civil rights violations by a local police chief. So the status quo that it's codifying is simply unacceptable. I should also note that RISA gives special treatment to members of Congress, requiring notification and consent by the members for certain queries of lawmakers that are not required for queries of ordinary Americans.
Excellent, thank you for that. And we'll come back shortly to some reforms that could help fix some of the problems that Liza's identified. I want to turn now to one of the other kind of challenges with sort of overseeing Section 702 surveillance. This is done primarily by the FISA court, and the court has the kind of option of seeking assistance from amicus curiae, right, who are outside experts who help, represent the public's interest before the court, because usually the court is hearing only from government lawyers. Now, there are a number of problems with how this program kind of works at the FISA court. Several of them were identified in the PFLOB report, right? A big one was kind of access to information, right, on par with the access that government attorneys have. And so there's been broad consensus for 4 years now in the Senate that FISA's amicus program should be shored up. Right, in 2020, the Lee-Leahy amendment, which would have reformed the amicus program, passed the Senate 77 to 19. It was never kind of taken up by the House, so unfortunately, it was never enacted. Senator Warner's FISA bill includes a watered-down version of this. It's also been incorporated into the Government Surveillance Reform Act and the SAFE Act, both 702 reform bills. So, Jason, I want to turn to you to talk about the amicus provisions in RISA, because there are some in there. There are changes to the program. Are they good changes?
The short answer is no, they're not good changes, and you got to keep in mind that that the amicus that are appointed by the court, one, FISA is a non-adversarial court, and amicus are only appointed if the FISA court basically says, yes, we need an amicus in here and to look at this. And this didn't exist until the Freedom Act in 2015, and it's still non-adversarial. The government still gets its way, or still gets the default by the FISC. But the problem that I see with this bill is one, we need to be strengthening the role of amicus that go before the court. We need to have, we need them to be bolder and have more issues and empower them more. What I see with the problem I see with RISA is that the bill makes it so that amici can only raise issues identified by the FISA court, whereas they can now raise issues and that they identify on their own, which they should do. And also, one of the particularly concerning aspects of this is, I believe under current law, the only requirement is that the amici have civil liberties experience. RISA requires that they also have essentially national security experience as well, that they have expertise in both privacy and civil liberties as well as intelligence collection. So most amici don't currently have that, and this would steer something like PCLOB into being only composed of former intelligence lawyers, or amici being only former intelligence lawyers who would default to the government. Again, it's already non-adversarial. This would turn it back into being, and it still is problematic, but this would turn it back into the pre-2015, pre-Freedom Act days, where the FISC was seen as a rubber stamp. And we need to have a more robust civil liberties presence in the amici role appointed by FISC, so that they can advocate for civil liberties rather than be called upon when the FISC allows them to or wants them to be included.
Excellent. Thank you for that. I have to say, both of those provisions are troubling to me. The idea that amici would only address issues raised by the judges on the court is kind of baffling, because the judges already have law clerks, right? If they've identified issues, they have people who can look into them for them. That the purpose of amici is to raise issues the judges might not have considered, and so it's truly kind of a baffling change. So I want to turn now to some of the amendments that the House made to RISA last Friday. Liza, one that we've heard a lot about, and some people are calling it the Patriot Act 2.0 or the Make Everyone a Spy provision, would expand Section 702's definition of electronic communication service provider. You had a great op-ed out in the Hill earlier today on this amendment. So I'm wondering if you can tell us a little bit about what this provision does and why it's a problem.
Yeah, sure. And if I leave you with nothing else today, I want to emphasize that this might be the scariest piece of surveillance legislation that I have seen in 17 years of doing this work, and I don't say that lightly. Senator Wyden has a long track record of being very prescient in raising the alarm about surveillance overreach, and he calls this provision one of the most dramatic and terrifying expansions of government surveillance authority in history. And unfortunately, he's not exaggerating. So let me explain how this provision works. Under current law, the government conducts Section 702 surveillance, as Sharon was mentioning, with the compelled assistance of electronic communications service providers, such as Verizon or Google, that have direct access to Americans' communications. The government serves directives on these companies requiring them to provide assistance, which generally means that they're turning over the communications of specified foreign targets. RISA vastly expands the universe of companies and entities that can be required to provide assistance, to include providers of any service whatsoever, not communications services, not data services, not tech services, any service, as long as the service provider has access to to equipment on which communications are transmitted or stored. Almost every US business provides some kind of service, and every US business has access to to equipment on which communications are transmitted or stored. They have phones, they have computers, they have servers, they have Wi-Fi routers. For businesses that offer Wi-Fi to their customers, this equipment will include not only the business's communications, but the communications of their customers as well. Although this provision of RISA exempts hotels, libraries, restaurants, and a handful of other establishments, the vast majority of US businesses will be fair game. For instance, department stores, barbershops, laundromats, hardware stores, dentist offices, fitness centers, and perhaps most worrisome, this definition would include the commercial landlords that rent out the office space that tens of millions of Americans go to work in every day, including offices of journalists, lawyers, nonprofits, and others. Now, unlike Verizon or Google, most of these businesses will not have the technical ability to isolate and turn over foreign targets' communications. So they will most likely be required to give the NSA access to the equipment itself, and therefore to all of the communications rooted or stored on that equipment, including countless communications between and among Americans. And the NSA would then be on the honor system to extract and retain only the communications of foreign targets. The administration and the Intelligence Committee members, or leaders, I should say, have portrayed this as a narrow fix to a FISA court ruling that the government was not able to compel assistance from a particular type of provider. The New York Times reported yesterday that that provider was a data center for cloud computing. But while the problem that they're trying to solve might be narrow, the fix they came up with is anything but narrow. It literally sweeps in almost every US business you can think of. It's like using a bazooka to kill a mosquito. The FISA court amicus who participated in this particular case explained why they drafted the provision so broadly. In his words, and I'll quote, "The amendment doesn't narrowly close the gap. Because they won't name the specific type of provider they want to cover, they are drafting overly broad language that will be interpreted to cover a variety of services, not the limited specific service they need to claim it for. They claim to need it for, apologies. So in other words, the provision was deliberately written in this incredibly broad language so that people wouldn't be able to infer the specific type of provider it's intended to address. Now, it's possible that the Biden administration only plans to use this provision to compel assistance from data centers. That could be true. But there is absolutely nothing to prevent a future administration from making full use of the power that this amendment on its face provides. And that administration will have unprecedented access to the domestic communications of Americans. No democracy should allow its government to have such an Orwellian power. I cannot overstate the importance of the Senate voting to remove this provision if there's an opportunity for amendment. And if not, the Senate should not pass this bill.
Thank you for that. That's incredibly troubling. So Sharon, I want to talk to you about another amendment that passed the House that would also expand surveillance. So this one would require intelligence agencies to develop procedures for using Section 702 to vet people applying for travel to the United States. Now, in the Pete Flob's report on Section 702, you made a number of recommendations as to how Congress should update Section 702. This wasn't kind of included in that list. Do you view these changes as necessary, and are you concerned about how they could be implemented?
So I should clarify that it was a recommendation by our minority. However, not one that the board put forward, and not in any way one that I believe is at all necessary. It does not have the same capacity to expand government surveillance in the way that Liza just outlined with the other amendment. And I do want to join Liza in urging that your bosses vote for an amendment to strip that provision. But with this one, the NSA already got permission from the FISA court for an expanded ability to use 702 data for vetting of non-Americans seeking to travel to the United States. And they already got what they need. It also is worth mentioning that even before that permission from the FISA court, the government has the ability to conduct queries when they meet the query standards. So if they actually believe that running a query is reasonably likely to lead to foreign intelligence information, so if they have some reason to suspect this person applying to travel here, they already can run a query. And with last year's FISA court opinion, they got an expanded ability, although still somewhat narrower, to for a 3-step process for travel vetting with key limits that are classified, so I can't go into what they are, but you can see in the language of the amendment coming out of the House that it requires procedures to allow vetting of all non-US persons seeking to travel here. And this should be an opportunity for Congress to reform Section 702, to improve guardrails, not to expand it.
If I could just jump in for 1 minute and just say that there are multiple robust vetting mechanisms already in place to ensure that visitors to this country do not pose a national security threat. A lot of them put in place after 9/11. And there's been no showing that they are somehow inadequate, and that this especially intrusive measure of looking at communications needs to be layered on top of that. And also, I want to make clear that this would affect not only people outside the United States who are seeking permission to travel into the country, it would also include visa holders who are longtime residents of the United States in many cases, but who still require authorization to re-enter the country when they take trips overseas. So we're talking about large numbers of people inside the United States, lawfully inside the United States, and subject to the protections of the Fourth Amendment.
And if I may, on the drug trafficking one, the one that relates to the fentanyl and international drug cartels, I have a lot of expertise in criminal justice. For those of you who don't know me, I worked on the First Step Act, very involved in that in 2017, 2018. We have been engaged in a war on drugs for more than 50 years, and we spend a lot of money. About half the money we spend is basically trying to address the supply side of illicit drugs, and the other half basically goes to addressing demand. This is an escalation that in the war on drugs that I will tell you right now will not be successful. The best way to address this issue is on the demand side, not on the supply side. Because if you're reducing demand through drug treatment and other programs, diversion programs, things like that, you can address the underlying issue and reduce demand for drugs. But it's not going to stop the flow of illicit drugs coming into the United States.
It's also, if I can add on again, I'm sorry, but it's also just completely unnecessary because the government is already using Section 702 heavily. I mean, they've talked about it a lot to go after fentanyl trafficking. So they're making robust use of Section 702 for that purpose. They claim that they are somewhat limited because the existing certifications, that's the topics that the FISA court has approved for surveillance, are foreign governments and related entities, counterterrorism, and weapons of mass destruction. So that if they want to do drug trafficking, it has to somehow connect to one of those three. So it's not the full set of drug trafficking. But of course, maybe not of course, you don't actually have to amend the law to change that. They can just go back to the FISA court with a fourth certification for drug trafficking. And the court has to approve it as long as it relates to foreign intelligence. And foreign intelligence is defined in the statute to include any information that even relates to the security of the United States, among other things. So unless people think the FISA court is going to say that international trafficking in dangerous drugs is unrelated to the security of the United States, and it's not going to say that, they can get that fourth certification. And so given all of the surveillance abuses we have seen in these last few years, Congress should not be expanding the core definition of the statute, the definition of foreign intelligence, without a pretty strong showing of need. And in this case, there's been no showing at all.
Thank you all for that. It's very helpful for my understanding as well. So Jason, I want to come to you and talk a little bit about the politics here, right? We've been talking a lot about kind of the policy and the policy concerns that we all have. But this is also a kind of political problem, right? And so we've identified some problems here, right? That RISA, kind of the base bill would fail to prevent future abuses of Section 702, that it would expand warrantless surveillance. Are these problems partisan issues?
No, they're not. And one of the things I'm fortunate enough to get to work on a couple of different issues where bipartisan coalitions are really what makes everything tick. And the coalition I've gotten to work with on FISA 702 in the past couple of years has been particularly awesome because we all have different ideological views and perspectives and political views, but we all agree on this one thing. Whether that we need to address and reform 702 in meaningful ways, not this sort of monstrosity that's come out of the House that's being called reform that isn't actually reform, or reforms that are significantly watered down. Obviously, last Friday in the House on the vote on the warrant requirement, you had 128 Republicans join with 84 Democrats to support a requirement to essentially close the backdoor search loophole. Unfortunately, you had another 212 to 212 voting against the warrant requirement, so it tied and it failed, unfortunately. But polling, and FreedomWorks partnered with Demand Progress earlier this year on some polling that shed some light on where Americans are, and asking Americans if they think privacy protections against warrant government surveillance should be expanded. 78% said yes. Only 9% said no. Thinking about warrants, should they be required before searches of Americans' communications with people abroad? 76% said yes. Only 12% said no. That shows you the sort of the breadth of support here, and again, bipartisan support as well. Sparing you from the crosstabs discussion, but you can go to FreedomWorks website or Demand Progress and see the polling information. But one of the things that was pretty interesting, you had majorities concerned about surveillance abuses, both targeting the left and the right. The question, would you be more likely to support or oppose a law requiring agencies to obtain a warrant before conducting the search if you knew government agencies had unlawfully searched for communications of people protesting the murder of George Floyd? 54% said more likely to support. Only 18% said they were more likely to oppose, and 28% said it would have no influence. And then the same question essentially of January 6 suspects, and 54% again said they were more likely to support, and only 21% were likely to oppose, and 25% said it had no influence. And given the state of everything in politics and the hyper-partisanship that has infected it across the board, it is indeed heartwarming to see both this strange bedfellows coalition coming together and supporting the Fourth Amendment, supporting Americans' civil liberties. And I hope to see more of it, not just on this, but on other issues. But this is a good way to go.
I couldn't agree more with that. And I have to imagine that members salivate when they see an issue on which 75% of Americans agree. So that's really kind of helpful to hear.
Yeah, I once had a pollster tell me if it's a 60-40 issue, you run with it. And here you have these three questions above 75% and opposition below 20%, in some cases single digits. Yeah, you run with that, and members should really be paying attention to that.
Absolutely. And folks, I did put a link to that poll in the chat, so you can take a look at that for yourself. So, Jason, I'm kind of glad that you mentioned the warrant amendment, because that's what I wanted to turn to next, right? I think it's important for us not to just kind of talk about what we're against, but also what we're for. And so, Sharon, I want to talk to you about this warrant requirement, right? Like Jason said, there was an amendment that would have added a warrant requirement for U.S. person queries to Section 702. It failed in the House by a tied vote, which I didn't even realize was a thing. So it's kind of quite disappointing, but we expect that a warrant amendment might well be kind of offered in the Senate. So I want to ask you, because I know that you have kind of written about this in your separate statements to the PCLOB report. Do you view a warrant requirement as a necessary protection for Americans' privacy?
Absolutely. And I want to be clear. Yes, I wrote further in my separate statement, but it is a board recommendation for that there be a FISA court review here. And I just wanted to, maybe clarify for the audience, there are a number of different terms that people use that are really referring to the same thing. So the government will talk about U.S. person queries because they are ways that they search through the collected data under 702 using terms associated with U.S. persons. A lot of privacy advocates, you'll heard that already today, talk about the backdoor search loophole. And I want to talk a little bit about why those are the same things and why it is absolutely critical that in reauthorizing Section 702, Congress should include a warrant requirement for U.S. person queries. And so the board's recommendation was for having this individualized judicial review for U.S. person query terms. The board's recommendation didn't use the term warrant because we had some discussion about what exactly the standard should be. But the board's recommendation made absolutely clear if Congress determines a probable cause standard, the board fully supports that. And I wrote further in my separate statement about why that is so critically important. And so why is it so important that Congress includes this warrant requirement for U.S. person queries? First of all, the Fourth Amendment requires it. The Fourth Amendment requires independent judicial review when the government is searching through its collected communications for information about specific Americans. I already talked at the beginning about how at the front end, at the collection stage, there is no individualized judicial review because those targets are not people with recognized Fourth Amendment rights. But when you get to the query stage, we're talking about Americans' communications. Americans absolutely have protected Fourth Amendment rights. And the collection of the data is I don't want to go into too much Fourth Amendment weeds, but the collection is a seizure and the query is a separate search, and we need to have this warrant requirement. Also, as I mentioned before, targets themselves don't have to be wrongdoers. They can be unwitting of anything going on, why they even know foreign intelligence information. So when you talk about the Americans in these databases who are in communication with the targets, they can be far removed from wrongdoing. In addition, we have a situation where we are collecting content of communications, and the content of communications can be very sensitive. This is significant privacy risks. We're talking about potential for political and religious views, personal financial information, mental and physical health information, very sensitive communications that in every other context, our law requires the government to get a warrant in order to access the content of communications when we're talking about other law enforcement actions. And further, we already talked a bit about the abuses that we have seen, in particular by the FBI, including the social justice protesters, members of Congress, and so on. And this persistent pattern of noncompliance by the FBI in particular dramatically illustrates the need for independent, impartial, and external review.
Thank you for that. That's I think, quite compelling. I want to stick with you for a moment, though, because one of the kind of counter arguments that we've heard from the administration and from some folks in Congress is that a warrant requirement would compromise national security, right? We were talking before we kind of started the presentation, and you referred to this as the sky will fall argument, right? And so I'm wondering if you can address that and say if there's any reason to believe that a warrant requirement would make Americans less safe.
Thank you for that. I think that's a really important question, and we have heard all sorts of arguments from the government. And the key problem here is that the government is conflating the value of the program overall with the value of U.S. person queries. And one thing I didn't mention at the top when I was talking about, PCLOB's review here, our agency, we are an oversight body. We do oversight looking at privacy and civil liberties issues. We all the board members, all of our staff have to have top level security clearances. we had access to the classified information on how the program operates, on the uses of the authority, on the value propositions and the examples. And we were able to put out our report with everything that can be declassified, which is fairly comprehensive. But we've looked at these examples and the government is conflating. I absolutely agree with the government when they say Section 702 overall is a valuable program. It provides important, critical access to foreign intelligence information to help keep us safe. Congress should reauthorize the program, but only with reforms. A clean reauthorization is not something that Congress should do. And we're looking at, Liza already talked about how this is a reform bill in name only. And just to be a little bit more specific, requiring a warrant for U.S. person queries would neither end U.S. person queries nor undermine the value of the 702 program. And I think that's a really important takeaway. The key examples that they have provided to us where U.S. person queries have been valuable are what they now call victim queries or defensive queries, and where they've been able to use the 702 database to identify potential victims, particularly of cyber attacks, reach out, warn them, and even say to them, hey, give us your selectors, give us your email addresses. We can, see if we can find out more information and help you to protect yourself. Outside of that context, FBI was unable to identify to us any cases in which a Section 702 U.S. person query provided unique value in advancing a criminal investigation, and they have been unable to identify a single criminal prosecution that relied on evidence identified through a U.S. person query. So I think that's critically important. They have other tools available when they are engaging in those criminal investigations, other tools available when they are engaging in those prosecutions. And when I hear statements that a warrant requirement will gut the program, I could not disagree more strongly. We have seen tremendous examples of value of this program. Not true for the U.S. person queries. Do they have a value? Absolutely. But posing a warrant requirement will not stop those queries, and particularly not in the cases where they have been most valuable. And then the final point I want to make, because I know that my other panels will want to weigh in here as well, is the warrant requirement amendments that we saw in the House, and I don't know exactly what form will hopefully come before you in the Senate, before your bosses in the Senate, builds in key exceptions to address the concerns that the government has raised about how this would slow down the process for the queries. It includes exceptions for exigent circumstances. It includes exceptions for consent. I mentioned the defensive queries where they can reach out and warn somebody and say, tell me your email addresses, and we can, make sure to run that through and ask for consent. It also, because a lot of those examples have come up in the context of cybersecurity, and certainly a cyber attack could be much broader based, has been, where there are so many victims that reaching out and providing, getting a consent from all of those individuals might not be practical. There's an exception for cybersecurity. And the queries, the warrant requirement would only apply where they are seeking content, not just the metadata. So the amendment that was in the House, and I assume that any version that will come before you as well, really has been tailored to address those concerns on how a warrant requirement would otherwise slow down the process in obtaining those approvals. So very important amendment.
Excellent. Thank you very much for that. And I will say, personally, this is something I find very frustrating, working outside of the government on these issues, because I don't have access to all of that classified information. So it is good to hear that, our kind of assessment of the information that's available in unclassified form kind of comports with your assessment, having reviewed all the classified information. So folks, we do have a couple of more questions that I want to get to, but we are kind of nearing the end of the pre-planned portion of the program. So if you do have questions, please put them in the Q&A box. We already have a few really great ones in there that I'm looking forward to having our panelists answer. But please get them in now if you have things that you would like them to address. So, Liza, I want to turn to you with another concern that we've heard both from the administration and from some in Congress, right? Which is that if the Senate makes changes to RISA, right? I think we've all talked about how we would like to see the statute amended. But if the Senate makes changes, Section 702 could temporarily lapse, right? It's set to sunset on April 19th, right? It's the end of this week. If the Senate passes a different version of the bill, it'll have to go back to the House, and we could see a kind of temporary sunset. If Congress allows that to happen, is Section 702 surveillance going to come to a screeching halt?
Yeah, it's not at all. But let me just also say, no, I think maybe this should be the last question so that we can, I get the last word because I think we do have a few questions. I want to make sure people have time to ask them, but this is really important. So let's just end with this. Section 702 surveillance would not stop if the law were to expire temporarily on April 19th while the Senate does its work. On April 4th of this year, the FISA court issued an approval of the certifications that the government had submitted that will allow the government to continue Section 702 surveillance until April 2025. And there's a provision of the law of FISA that states that these certifications issued by the court will stay in place until their expiration date, notwithstanding any other provision of the law, including the sunset. By the government's own interpretation of the law, this certification that the court issued effectively grandfathers Section 702 surveillance until April 2025, even if Section 702 were to expire. Now, the administration has said that. They've said, we get to conduct surveillance until 2025, even if Section 702 expires. But they nonetheless have hypothesized that if 702 were to expire, companies might decide not to comply with government directives to turn over foreign targets communications due to the, quote, legal uncertainty. And the evidence that the government cites is the fact that some companies briefly refused to comply with directives issued under the predecessor to Section 702, the Protect America Act, after that law expired. But that's a red herring. Congress passed Section 702, and when Congress passed Section 702, it made sure that this would not happen again. The Protect America Act did not state that FISA court certifications would continue to be valid, notwithstanding any other provision of the law, meaning notwithstanding the sunset. That language was added to the FISA Amendments Act, that was the law that created Section 702, to erase exactly the kind of legal uncertainty that the supporters of RISA are now postulating. I should also point out, companies can't just choose whether to comply with Section 702 directives. A company that fails to comply with a valid directive faces very harsh penalties, including fines of up to $250,000 a day for noncompliance. I don't see a lot of companies risking that in this situation where the FISA Amendments Act says that the court's order approving 702 surveillance remains valid until April 2025. And finally, if the administration is wrong, and if companies are able to raise valid challenges, the collection won't stop while those challenges are moving forward. I would bet my life that the FISA court will require companies to remain in compliance pending resolution of the challenges, which would likely take months. So even in what the administration would consider to be the worst case scenario, there will be no sudden drop off in intelligence collection. The point I want to underscore overall, and most of all, is that the Senate has the time it needs, and it must take the time it needs to get this right. Senators cannot be rushed into passing a law that will create the most dramatic expansion in domestic surveillance in the past 2 decades.
One thing real fast that I wanted to associate myself with Liza's remarks earlier about the everyone is a spy amendment that was added on the House side. And she talked about how this amendment is unacceptable in a democracy, and she's absolutely right. We are facing the rise of illiberalism and the rise of authoritarianism in the United States that is quite alarming. And I think it's, in my perspective, it is impossible to complain about the weaponization of government and then vote for a bill that will almost certainly guarantee that government will continue to be weaponized in the future. This is a point I raised to D&I Haynes in September of last year, and no real answer was given. but it's something that alarms me. So I will now shut up.
Well, thank you very much to all of our panelists. We're going to turn now to the Q&A section. So I am going to turn off the recording, as I mentioned earlier. So again, if you're viewing this afterwards and have questions, please send them in to me. I am more than happy to answer them for you.